Welcome to WEDA's Friday Exchange, a media product of the Washington International Trade Association. Each week, we bring you inside the room with former trade negotiators and policy insiders to unpack the latest in trade and tariff developments, what's been announced, what's at stake, and what might come next. Imagine our speakers are sitting at a local pub after a tough week at the office or at the negotiating table, downloading with their colleagues about the latest developments in international trade. That's what we aim to bring you with WEDA's Friday Exchange. New episodes drop every Friday. Subscribe on YouTube, Apple Podcasts, or Spotify to be the first to know when they go live. Before we get into this week's discussion, we had a chance to speak with Rick Woldenberg, the CEO of Learning Resources, whose lawsuit challenging the legality of the IEEPA tariffs is pending before the U.S. District Court, and which our speakers will talk about during today's podcast. I wanted to just ask you a few questions about the case. So why did you bring it? What was the reason that you wanted to bring this case against the tariffs?
Well, on the stump, Mr. Trump had said that China tariffs might go as high as 60%. No one thought anything that crazy could ever happen. When he hit us with the fentanyl tariffs of 20%, we began to work on climbing the mountain of not letting that sink us. But in April, it went from 20% to 145%, which was an existential threat to our business. And I can't stand by and let politicians destroy what we've been working on for over 40 years. So we had to take action.
What do you think what has been the impact so far of the tariffs for Learning Resources?
It's been unbelievably disruptive, and it's wasted a lot of our money. So we have upwards of 30% of our office team working on tariffs, either full-time or part-time. We're trying to move hundreds, if not literally thousands of items from China to other countries. As everybody knows, the rules on tariffs change on an every other day basis, and so it's not really possible to have confident ideas to whether you're making a good decision or not when you move it from China to some other place. For instance, as of today, the tariffs in India are higher than the tariffs on China, which is shocking. So very disruptive. It costs us a lot of money, millions of dollars, to move products. So every product has a lot of costs associated with that kind of transition. And, it's slowed down product development. It's caused us to delay and to shrink product releases. Our company has lower revenue. We've had to raise prices. It's just disruptive in every way.
So, by the way, just tell us quickly about Learning Resources. What kind of products do you make? How many people do you have working here?
We have two companies, Learning Resources and Hand to Mind. Together we have over 500 employees. We make educational products and educational toys, and we also make some dog toys. Our products are found in schools and in the home. We're widely distributed. We sell in over 100 countries. We have over 500 employees. It's a family business. The original family business dates back to a company purchased by my grandfather in 1916. So our kids are fourth generation in this business, and it's a mission-driven business. So our purpose is to help kids get a great start in life, and that's another reason why, the tariffs were a very serious threat. When you're a mission-driven business, and when you have a legacy of over 100 years of creating jobs and paying taxes and supporting your community, there's a lot of high stakes when a politician changes the rules and can threaten this. And we also always think about the 500 families that depend on this company for their livelihood. All those things are, bounce around inside your head when a big threat comes your way.
Sure, and we're sitting here today in Vernon Hills, Illinois. Where are your employees based? Are they mostly around here?
I would say about 2/3, maybe a little bit more, are based in Vernon Hills. We have an office in the Los Angeles area, in Torrance, California. We have a small office in Buffalo, New York. And we have about 50 people working for us in the UK, north of Cambridge.
Fantastic. So this is a big impact, not just on this company, it's the whole community with that many employees.
We think about how many lives we touch with our products and how we do business, and there's definitely millions of children that depend on our products in their schooling. We're in millions of homes. There are thousands of businesses that resell our products. We have vendors that we care about. The taxes that we pay support the local schools and the police department, and over 100 years we've employed thousands of people, and thousands of families have been affected by the continuing health and well-being of this company. So we see the stakes as being very, very high.
So you brought one of the cases against the government for the tariffs. What do you think? Do you think you're going to win?
Oh no, we're going to win. We're going to win. The tariffs are an illegal tax, and they're against the Constitution, they're unauthorized, and they were illegal as imposed.
Thanks, Rick. Appreciate it. We're recording this week's episode on Wednesday, August 20th at 9:30 a.m. U.S. Eastern Time. So depending on when you download and listen, the trade and legal issues we are discussing today may have changed. Since the president announced his off-again and mostly on-again tariffs, we've seen several legal cases winding their way through the courts. Most observers expect the cases to be decided by the Supreme Court in their fall term, which could throw out all or some of the president's most broadly imposed tariffs or allow them to remain in place. On today's episode, we're taking a slight curve from our normal discussion of trade policy and negotiations to welcome an all-star panel to look at the legal challenges to the president's tariffs and what we may see in the weeks and months to come. I'd like to welcome Kathleen Claussen, professor of law at Georgetown University Law Center and a former associate general counsel at the Office of the U.S. Trade Representative. Peter Harrell, a non-resident fellow at the Carnegie Endowment for International Peace and a former senior director for international economics and competitiveness at the National Security Council. Marty Letterman, professor of practice at Georgetown Law and a former deputy assistant attorney general. And our moderator and discussion host today, Michael Smart, managing director at Rock Creek Global Advisors and a former director for international trade and investment at the National Security Council. Mike?
And thanks a million. And very lucky to have this group of panelists today to talk about the pending IEEPA cases, two of which are before federal courts of appeal. Before we jump into those cases and talk about how the courts might rule and on what timeline and what issues will be important, we wanted to kind of set the table just a little bit, beginning with the broader kind of constitutional and statutory framework that involved the power to impose tariffs. Our audience will know that the Constitution gives that authority to Congress, but it's been delegated many times over many decades. And so, Kathleen, can we start with you and just help us a little bit with that context? What does Congress delegate this authority explicitly? How does it do so? What are the terms and conditions it imposes? Let's start there before we move on to the specific cases. Over to you, Kathleen.
Mike, thanks. Well, let me emphasize your foundational point there that the president's power over foreign commerce, including tariffs, that power is purely statutory, right? That's how the Constitution is set up. There's no general foreign affairs, foreign commerce power in this respect. Everything that the president can do has to be in a statute. Okay, well, then, as you suggested, there's quite a bit there. Congress has delegated frequently to the executive branch to do things that we would say counts as that regulation of foreign commerce, especially over the last century. So the most well-known example of this authority that I think many of our listeners will know is trade remedy statutes. Right, those statutes allow the executive branch to increase tariff rates on imports to counteract unfair trade practices or import surges that are harming domestic industries. Those get used frequently. They've been used regularly for several decades. That's a pretty obvious set of statutes that will be familiar to the trade community. Less well known, at least until maybe we'll say 2017, are what I've called the three-digit tariff statutes. And these are authorities that allow the president to impose tariffs, to impose trade barriers on an exceptional basis, where he deems that doing so is necessary for U.S. economic security. I call them three-digit tariffs because we often refer to them by their three-digit section of Title 19 of the U.S. Code. Section 232, Section 301, Section 201. They've been in the news a little bit lately. So those are the authorities that Congress has delegated to the president to raise barriers to trade. Now, there are also authorities Congress has delegated to lower barriers to trade. Those haven't gotten as much attention. We don't need to spend time on those. But of course, there I'm talking about the authorities associated with entering into free trade agreements, trade promotion authority. Okay, so summing up, Mike, Congress has delegated these sort of two different strands to the president. The one strand enables him to raise barriers when security requires, and the other is to lower them in mostly free trade agreements. You also asked me about terms and conditions, and there's a discrepancy between the two camps. For the tariff raising statutes, Congress has not required much, not much congressional oversight over those that allow him to raise tariffs, not much in terms of judicial review. But with respect to the tariff lowering statutes, Congress has imposed quite a bit of oversight over the years, and we know that from the politics of free trade agreements.
Terrific. Thank you, Kathleen. And in the trade remedies and three digits, you didn't mention IEEPA. Maybe you could give us just an intro before we get into the cases. I mean, what's the argument that this statute belongs among the delegations of tariff authority, and what are the arguments against that?
IEEPA, well, everyone's talking about it now, right? We talk about it over dinner. Well, maybe only in my house. But if we were in class, Mike, we would definitely pull out our copy of the U.S. Code. We try to find IEEPA. We wouldn't find it in Title 19 that I mentioned. But since we're only chatting at the exchange, we won't go through it word for word. I'll just go through one particular word, perhaps, that matters a lot. And it's the one that's not there, tariff. IEEPA does not mention tariffs or duties or any other synonym. So what does it say? Well, in essence, it says that the president can regulate any importation or exportation of a good. Now, sticklers are going to get on to me for not telling that so precisely, but I think that's where we want to start. A lot of the argument has focused on the meaning of those words, regulate, importation or exportation, the lack of the mention of a tariff, right? Regulate doesn't say tariff, it's not the same. The word tariff does appear in those other statutes I was just talking about, the three digits. So the fact that tariffs are not expressly mentioned, that leads into a couple other arguments that I think we'll come back to later. One concerning whether Congress can delegate such authority at all, right? That's pretty big to just say regulate and to read tariffs into that. And the other about whether it can do so without saying that very clearly. So two big sort of more, we'll put them in the constitutional arguments area, and we can talk more about. Now, there's one other part of IEEPA that I think we should mention that has also come up, which is really its foundation on another law about national emergencies. So the way IEEPA is set up, before the president can do anything at all, he has to declare a national emergency regarding an unusual and extraordinary threat. So the questions under debate here are whether the emergencies that the president has identified are based on an unusual and extraordinary threat. For example, the trade deficit is that one such thing. And then secondly, whether there's a nexus between the tariffs and these underlying emergencies. So will the tariff solve these problems? So I think, Mike, that's maybe as much detail as I'll start with, at least over our drink here at the exchange. And there's much more in terms of history, earlier case law, binding precedent on one of the courts here, the availability of these other statutes that he could have used. And that's just from the parties to the cases that I think Peter and Marty can tell us more about. In addition, we have nearly 20 amicus briefs that amplify and elaborate on these and other arguments. So we could really be here late into the night. So I think we better just leave it there to start.
No, that's a great transition. Okay, so on to the cases. Marty, can we start with the case decided by the Court of International Trade that is now before the Federal Circuit? Just give us a little bit of grounding there. Who are the claimants? What did they claim? What did the CIT rule? And what's the current status of the proceeding before the Federal Circuit? Marty, over to you.
So there are several different plaintiffs, people challenging, including a number of so-called blue states and private parties who claim to have been harmed by President Trump's tariffs. And they brought suit in this specialized court. It's a court that deals predominantly with patent questions, or it goes up to a court of appeals that deals predominantly with those questions. The U.S. Court of Appeals for the Federal Circuit. but they also deal with tariff issues on occasion on appeals from this Court of International Trade, and that's where the case was filed. Peter will probably talk about a second case filed in one of our more ordinary or more familiar federal courts, the District of Columbia, outside of that particular litigation statutory scheme. But the likelihood is that the case that's before the so-called Federal Circuit, that was argued back, I believe, on August 1st or thereabouts, that case will probably be the vehicle by which this gets to the U.S. Supreme Court and is ultimately decided. And in that case, the Court of International Trade did not hold broadly, as did the district court in the other case that Peter will mention, did not hold that IEEPA does not give the president any tariff authority at all. That's sort of the high level argument, is IEEPA does not give the president any authority to impose tariffs, that the word regulate imports does not include the power to tax imports. I would be very, very surprised if that argument prevails ultimately, either in the Federal Circuit or in the Supreme Court. I think Pratik Shah for Aiken Gump has done a wonderful job briefing that in the DC case, and others have briefed it well in the Federal Circuit case as well. But I don't think they're going to be, I think the judges and justices will be reluctant to issue such a broad categorical ruling that that the president can never use tariffs to accomplish ends where there are true emergencies, and that they are, to deal with unusual and extraordinary threats, which is what the predicate is here. So there are a couple of other types of arguments being run. Two of them Kathleen already teed up, and those I call those sort of the big picture arguments. One is that IEEPA is unconstitutional because it's delegated too much unbounded authority to the president. And the other, and that's related, is more of a statutory argument with a constitutional overtone. It's the so-called major questions doctrine, which the Roberts Court has been quite keen on in recent years. And that's the idea that just as a matter of interpreting what Congress has done, we don't assume that Congress has delegated major questions to the executive branch, absent a clear statement to that effect. It's just sort of a presumption of legislative intent. Those two arguments, and another that I'll mention in a second, have played an overwhelming role both in the briefing and even more in the public discourse about this litigation. And those arguments have been made that the statute's unconstitutional, or at the very least that it should be construed under the major questions doctrine not to give the president either any authority to impose tariffs, or at the very least to have that tariff authority cabined in certain ways, although no one's exactly clear on what those ways might be yet under those doctrines. Again, for reasons I'm happy to discuss with you guys, and this is a somewhat, I guess, unorthodox view within the public discourse, although I think it's a commonly held view among the close watchers of the court. I would be very, very surprised if either the Federal Circuit or especially the Supreme Court rules against the Trump administration, either on non-delegation or major question grounds. I think everyone, in part because IEEPA is a much broader statute, right, that has been used by the executive branch for decades to do a lot of very, very important things. Presidents have used it extremely aggressively and creatively and broadly, and the courts are not going to be eager to use this case to be imposing new constraints on IEEPA, at least not without knowing much better what the implications of such a holding would be. And so those arguments might play kind of a background role and give a little bit of pause to some of the judges, but I would be very, very surprised if the administration loses on either of those two grounds. A third ground, and this is the hard one. Kathleen mentioned that IEEPA requires the president not only to make a declaration of an emergency, but to say that he needs to use IEEPA, however he's using it, through tariffs or otherwise, to deal with, that's the statutory language, a threat that is both unusual and extraordinary. And I have to say, that's kind of, I've always sort of marveled at that. Like, can it be extraordinary without being unusual? Well, anyway, it's got to be both extraordinary and unusual. And President Trump has made that declaration. He's declared that that there is a threat out there, there is an emergency, and the threat is one that's unusual and extraordinary. And here's sort of the 2,000-pound gorilla in the middle of the room. Virtually no one thinks that that's true, right? They think he has a lot of policy reasons for imposing these tariffs, and he thinks they're very important. But there's deep, deep skepticism among, I would think, among judges and Supreme Court justices and ordinary lawyers and citizens that President Trump's declaration that this threat is extraordinary and unusual seems to be pretextual. There's not much to it, but that runs into another set of problems, which is that in these areas of foreign affairs and national security, courts have traditionally been extraordinarily reluctant to look behind the surface of presidential findings of a extraordinary and unusual foreign affairs threat. And this Supreme Court will be very reluctant on the surface of its opinion to say, I'm sorry, Donald Trump, we just don't believe you. We don't think this is an unusual and extraordinary threat. But I do think the fact that everyone thinks, or many people think that that is pretextual, is sort of in the background here and is pushing judges to try to find a way to rule against at least some of these tariffs because they're afraid of empowering presidents and encouraging presidents to use pretextual findings to do things that Congress did not intend. And this is not a problem unique to this case or to the tariff problem. It's happening in case after case after case involving this president and this administration in the area of enemy aliens and immigration more broadly, and in funding cutoffs and in all other things. This administration, time and time and time again, is making either presidential or secretarial findings that are very, very, very dubious, but that have traditionally been deferred to by the judiciary. And they're exploiting that fact. They know that the judiciary is going to be very anxious about saying, bullshit, basically, we don't believe you. But that problem is persisting in a whole range of cases, of which this is just one very vivid illustration. So those are the arguments that I don't think will resolve the case. I think the case will be resolved one way or the other, or possibly both, as to, in favor of the Trump administration as to some of the tariffs, against them on others, on one of two more other statutory grounds that are narrower. And we can talk about those. That gets a little bit more into the weeds, but I think the one that has the most chance of succeeding, I'll just do it in great shorthand here, is that in the 1974 Trade Act, Congress seems to have prescribed certain limits, both in terms of the degree of the tariffs and the duration of the tariffs, to deal with so-called balance of payment problems, right? So if the president's concern is a balance of payment problem, Congress has already specified what the metes and bounds of those tariffs could be, and these go beyond those, and Trump has to go back to the drawing board and work within the terms of the 1974 Trade Act. I think that that's a very possible outcome in this case, and it would apply to some of the tariffs Trump has imposed, the so-called, well, what's the term that you folks have been using for it? The reciprocal tariffs, but not the fentanyl-based tariffs necessarily, which have in my mind, a greater chance of prevailing and succeeding with this court. I've said too much already, but that just shows that there's so many different arguments in these cases. I'm just trying to sort of give them an artificial sort of framing of them and suggesting that I think the narrower statutory arguments are those that are more likely to prevail for the plaintiffs on some of their claims, but with this issue about presidential pretext very much in mind in the background.
Marty, you've set the table well for Peter to come in now. Peter, in addition to talking about the case in the DC District Court, would love to hear your responses to the points that Marty has laid out about what might be the basis for both the appellate court and Supreme Court rulings. Peter, over to you.
Yeah, no, it's great, and it's great, Marty. I have the advantage of going after you, so I get to react to what you said and offer some areas of agreement, but also some areas of disagreement. So Marty, I think you're absolutely right when you look at the CIT opinion that is now on appeal in the Federal Circuit. The Court of International Trade basically found that the reciprocal tariffs are unlawful because, as you say, the Section 122 of the Trade Act of 1974 kind of, occupied the field for tariffs dealing with the trade deficit. The CIT also had a different argument for why it thought the fentanyl tariffs, the Canada, Mexico, and China tariffs were unlawful. The CIT's argument there was not spelled out any detail, but it basically thought the idea of tariffs on, many goods from Canada and Mexico and China was not sufficiently tailored to deal with the fentanyl crisis, that it found those tariffs unlawful. But as Michael, as you asked, like the CIT case, which is now on appeal in the Federal Circuit, is, well, there are two of them that are joined, but are really only two of maybe 7 or 8 cases that have been brought to date challenging the IEEPA tariffs. There have been cases brought in California, in Montana, and then one that has a merit or a preliminary decision in the District of Columbia, which is now in front of the DC Circuit. And it's interesting because the DC case, which is brought by an educational toy importer called Learning Resources, had a ruling that is both broader, but Marty, like you said, it's actually on statutory grounds. It doesn't really get into non-delegation doctrines or anything. The DC district court case now on appeal to the Court of Appeals for the District of Columbia, but where we're going to get a ruling, I think, after the Federal Circuit ruling. So I agree the Federal Circuit's in the driver's seat. But the DC case, Judge Contreras basically didn't get into big picture non-delegation questions. He kind of implicitly got into major questions, doctrine questions, but it was really a textual read of IEEPA. And finding that this language of regulating imports, that regulate doesn't include the power of tariff, and it sort of goes through all the reasons that just as a matter of reading the statute, regulate doesn't include the power to tariff. It hasn't been used to impose tariffs for 50 years. Just sort of the plain meaning of regulate in dictionaries doesn't, tariff or tax or duty doesn't usually come up. You also have other sort of arguments, the same power in IEEPA to regulate importation also allows the regulation of exportation. And export taxes are clearly unconstitutional. So, like, if you're going to read this statute to, sort of avoid constitutional questions, the court found you should read the power to regulate to not include the power to tariff. There's also the question, I think about this for, businesses around the country. If every time in the U.S. code, an agency that has the power to regulate now has the power to tax, kind of interesting about whether the SEC is going to start taxing financial transactions. Kind of interesting to think about, is the EPA going to start taxing carbon taxes, out of whole cloth? Like, I think there's some really interesting textual questions here. And basically the DC district court judge, going through all the kind of canons of textual construction, found that IEEPA's power to regulate simply doesn't include the power to tariff. I actually, Marty, I think that is likely to be the reason that prevails both at the Federal Circuit and at the Supreme Court. Now, I think that not only because I serve as co-counsel to some members of Congress who have made this argument in amicus briefs to the Federal Circuit, so I have a sort of an interest here. But the members of Congress argument is that there simply is no power to impose tariffs under IEEPA. But I also think it is the To your point, Marty, if you are a judge and you are thinking about the future of all of this, we have seen the president impose tariffs under IEEPA not just for the reciprocal and universal tariffs, not just for trade deficit reasons, but also for fentanyl trafficking. He's now imposing tariffs on Brazil because of, the Brazil's prosecution of former President Bolsonaro under IEEPA. He's imposing tariffs on India under IEEPA for India's importation of Russian oil. Like, I think there is a practical reality of if you open the door to any tariffs under IEEPA, the president is very likely to find pretextual reasons to impose a world of tariffs under IEEPA. And so I think that the sort of cleanest and most straightforward way to understand this statute in a way that, prevents sort of future use of IEEPA to impose tariffs under pretextual reasons is to simply find, consistent with the statute's text and history, that there is no authority to impose tariffs within the power to regulate importation.
Kathleen, would love to have you come in here on what you think the basis for a decision will be. Will it be basic, statutory interpretation? Will they draw a bright line? Tariffs, no tariffs? Sometimes tariffs are okay, but not in these circumstances. And then do you agree with the point that Marty made about staying away from a ruling that says IEEPA itself is unconstitutional, or kind of peeking behind the curtain at the national emergency declaration? Curious as to just your response to what Peter and Marty have laid out for us.
Well, there's so much there, really, Mike. I mean, Peter and Marty are the experts, both in court watching and in their participation in these cases and those that might affect these cases. Look, I would say a couple of things. One is it's so interesting to hear the framing of the cases, right? In the sense that some people say these are cases about taxes. This is about taxes, a domestic taxing issue. And others who say, well, this is a foreign affairs issue. This is all about, and of course, it behooves the government to think of this as a foreign affairs story. Behooves the plaintiffs to think of this as a tax story, and how you frame it, right, may influence how the courts then approach it. Now, of course, both there's foreign elements in Article 1, and there are tax elements in Article 1. And actually, Tim Meyer and I just finished a piece on this on the foreign commerce power, where if you go back to the drafting, you can see in the Constitution how the framers saw these as one clause in their original drafts of the Constitution, that the taxing, that duties, rather, tariffs specifically, and the regulation of foreign commerce go hand in hand. But I think the government here really tries to capitalize on this broad concept of foreign affairs, and thinking that will be something of interest to the Roberts Court. If there's a general foreign affairs power, right, then the president can exceed the statutory limits. It doesn't matter what it says there, because he's actually he's supplementing his own constitutional power as foreign affairs regulator in chief, right? So I think that framing may come out as we get to the Supreme Court, and sort of digging into those historical, constitutional, as well as statutory elements. And the other thing I would say here, perhaps, is listening to Marty and to Peter, that no matter what the Supreme Court says, Mike, as you said, maybe they'll be limited. Marty thinks maybe a mixed decision. This could have been a totally different conversation if we only had, for example, let's call them the secondary tariffs, what are now being called the secondary tariffs. We mentioned Brazil, but more specifically the Russia ones and the Venezuela tariffs that have been threatened and to some degree potentially imposed. These are using IEEPA to sort of get to maybe a real threat. If you can disagree about the threats that the president has said about fentanyl and trade deficit, but to the extent you think that Russia it falls in the category of something we might think of as a real threat, and the idea of using IEEPA to impose tariffs because of something Russia did, we might find a broader group of people who would be okay with that. You might not have the lawsuits that we have. And so you might have ended up in an outcome where IEEPA permits tariffs in those certain circumstances. So it's interesting to sort of think about the counterfactual. If this had all come about differently, if we saw IEEPA used differently to impose tariffs, you might not have had the sort of uproar that I think you have from these cases. And in fact, you hear some people talking about these cases as being ways that would overly limit IEEPA to do the things we want to do. Todd Tucker had a recent column on this, right? We might want to use IEEPA for tariffs, for things that other presidents think are important and valuable. So a real disagreement there, I think, on how we want IEEPA to serve our interests going forward, and whether using these vehicles has really overly limited the potential that we could have had.
And I would say, if I could jump in, I would say that, Kathleen, that's right. And the fact that those cases aren't before the U.S. Supreme Court doesn't mean that those hypos aren't before the Supreme Court. And I think that's the reason that I'm a little bit, although I think that Peter and his clients and Pratik Shah and others have done a really good job making the argument that regulate does not include imposing a tariff. I just think the court's going to be very reluctant to go there, because they will know about cases. For that matter, if you thought that this tariff would actually stop stop fentanyl from coming into the United States and save tens or hundreds of thousands of lives, I think people would think Congress would want to give the president that authority. Why the hell not, right? Like, that's very much something they would want to do. So one reason is that or the Russian hypo or whatever, however you have it, that'll be in the briefs, and that'll be in the minds of the justices, and it will make them reluctant to hold that the word regulate does not include a tariff authority writ large. They'll also be worried about making precedent about whether other statutes allow it. It cuts both ways, Peter. Both the word regulate and other statutes all of a sudden might become a taxing power, but maybe we don't want to cut it off altogether as to others. But there's another big thing going on here that's very IEEPA specific, which is that in 1975, the predecessor of the Federal Circuit issued a ruling, the Yoshida case, which plays a very prominent role in this litigation, in which it held, rightly or wrongly, that the predecessor to IEEPA that used the same language, the Trading with the Enemy Act, did authorize tariffs under the circumstances that, basically similar circumstances that IEEPA does. So that precedent was sitting out there. It was prominent. It was controversial. It was very well known to Congress when it enacted IEEPA 2 years later. And so the Yoshida example, a government's argument, which I think will be very attractive to the Supreme Court, is that Congress effectively ratified this 1975 understanding that regulate does include a power to impose tariffs under certain conditions. They will be reluctant to say that Congress said no, was rejecting that view. I might be wrong about that. The flip side, however, and this came out very prominently in the en banc oral argument before the Federal Circuit, which, by the way, was 11 judges, so it's a sort of a rambling, sort of not very focused oral argument, but it covered the waterfront of questions, is that 1975 opinion also said that when it came to tariffs that are covered by the 1974 Trade Act, the 74 Trade Act's metes and bounds govern, and IEEPA, that the president can't go beyond that. And so the argument being made by some of the judges on the Federal Circuit and by some of the plaintiffs in that case is, if you want to rest all of your case on this Yoshida ratification by Congress, you have to take the bitter with the sweet. And the bitter is that when it comes to balance of payments tariffs, you're bound by the limits of the 1974 statute. I think that's the most likely outcome. I don't know for sure. The judges on the Federal Circuit there seemed to be a lot of them that wanted to cabin this to whatever it was that the Yoshida case had decided, but there was a lot of difference as to what that might be. It'll be interesting to see what happens. There were a couple judges that thought maybe it should be remanded for further hearing on the question of whether this really does deal with the problems in a way that is sufficient there, or whether there's an evidentiary predicate for the president's finding of unusual and extraordinary threats. I doubt that's going to be the outcome in the Federal Circuit, but there's certainly some of the judges who wanted to go that way. They wanted to kick it back to the Court of International Trade. But Peter, that's why I'm a little bit skeptical. I'm sympathetic and admiring of the regulate doesn't include tariff argument, but I will be at least slightly surprised if that's where the court ends up.
Let me just respond a little bit, Marty. I mean, I think that I very much agree that Yoshida was in the background, is very much front and center of this case. And you heard, as you say, Marty, you heard several of the judges kind of say directly to the government's lawyer at the Federal Circuit argument, if you want us to buy Yoshida for regulate, including tariffs, don't we also have to buy Yoshida, for the kind of limits on how those tariffs are? The thing I would say, which makes me think that if the Supreme Court takes this up and ends up deciding on Yoshida-esque grounds, or if the Federal Circuit ends up deciding on Yoshida-esque grounds, I actually think in that world we may see something that does get into non-delegation doctrine issues. Because if you read Yoshida, it's not just the limits that the court talks about aren't just that in 1974 for balance of payments tariffs, Congress adopted Section 122. The Yoshida court also got into an analytic detail of, well, these 1971 Nixon tariffs were only in place for 4 months. They were capped at 10%, but where the 10% surcharge would have taken a tariff above the rate in the column 2 and the HTS, like it didn't go above, where there were things that had no tariff, that did not add tariffs, that only increased tariffs on tariff goods. And Trump's tariffs are just vastly broader than the Nixon tariffs. They are vastly broader in chronological duration, potentially open-ended for all time if the president has his way. They are at rates that we've seen go up to 145%, or I guess 125% were added tariffs on China back in April. They cover goods that were otherwise at zero tariff rates. They certainly exceed column 2 rates in certain ways. So I actually think that, like, if we're gonna buy Yoshida in full, it is gonna sort of force the courts to think about, well, can Congress actually fully delegate its tariff power over to the president to do, frankly, as we've seen him do, anything he wants on rate, duration, and product coverage.
Great. I want to push you guys a little bit on timing because, of course, that's of interest to the audience and businesses who are paying these tariffs today. So we had the oral argument in the Federal Circuit, I think 31st of July. We've got an oral argument before the DC Circuit end of September. When do you expect a decision out of the Federal Circuit? Will the Supreme Court wait for the DC Circuit before taking the case? And if and when the Supreme Court does take the case, what do you think the timeline would be? Would it be just regular order so we get a decision next spring? Might they act more quickly than that? I realize these are kind of unknowable questions, but would appreciate your kind of framing up the issues and how decisions around timing might be made. Who'd like to jump in first?
One thing about the DC case that we haven't mentioned that complicates it there, which is that there's a jurisdictional question that comes before the merits in the DC case, which is what the question the government argues that these cases have to be brought before the Court of International Trade and go up through the Federal Circuit. I think the government is likely but not certain to win on that ground in the DC Circuit, depending on the panel there. So I will be surprised, but it's not inconceivable that the DC Circuit will reach the merits. Depends, I think, on how eager the judges there are to reach the merits. But probably I don't think anyone's going to wait for the DC Circuit because there's no certainty at all that they'll reach the merits. So I think that unless the Federal Circuit comes up with some sort of remand solution to kick the can down the road, I think that once it decides, that will go up to the Supreme Court. It probably will be decided this coming term of the Supreme Court, that is by the end of June, based largely on what the Federal Circuit has said. If there's judges on the DC Circuit who have weighed in by then, all the better. But and then I guess there's a really important question about what the status quo is between now and June. in terms of the injunctions that are out there, whether they are stayed. And what the parties ask the Supreme Court to do with respect to the interim period, right? Whether they ask the court to let the injunctions against the tariffs stay in place, or whether the default rule will be the tariffs are in place until the court rules. I don't have a good sense of that, because in part because I don't know what the practical implications are of having these tariffs in place for 8 months, only to perhaps have some, but not all of them, invalidated at that point. But you folks would know better than I on that. But it's something to watch for. I bet there will be briefing on the so-called interim question.
So the president's made clear he thinks the sky's going to fall if the tariffs don't remain in place. At the beginning of last week, the Solicitor General filed a letter with the Federal Circuit saying that in the president's view, it was an interesting letter. It did not say in the Department of Justice's view. It said in the president's view, millions of Americans will lose jobs. Medicare might go bankrupt. Will be unable to, keep in place the basic functioning of the U.S. government. But to your point, Marty, I think the government is very much teeing up sort of its equitable arguments that even if it loses at the Federal Circuit, the tariff should remain in place while this goes up to the Supreme Court. I agree with you. I mean, if you're the Supreme Court, you're looking at this. If the government is allowed to collect tariffs all the way to, say, June of next year and then loses, at that point, it is going to have to refund something like $300 billion of paid tariffs. I mean, like at that point, it actually becomes sort of a non-trivial issue for the government. On the other hand, the government is, and I think the plaintiffs in the lawsuits argue if the government's collecting tariffs, till next June, especially for small business importers, like they are facing real financial strain and real fiscal strain from having to, at that point, having paid tariffs for more than a year. So I think it's going to be a little bit hard to know where the courts will come down on that. I obviously think that the courts, if the Federal Circuit rules against the tariffs, I would hope that the Supreme Court lets the injunction come in and does not, we do not see tariffs collected, but we'll see what the Supreme Court actually does.
My 2 cents on that, Mike. I think that agree with a lot of what's been said, but I've always said to, at least to our trading partners who are also, we haven't talked about them and how the agreements are now being, or maybe not being made, how the litigation is very much a distraction for them, I think, right? Because we've said there's so many other ways the president could impose tariffs. To the extent we're talking about tariffs as a way of bringing partners to the table, that will continue. So agree that there are real consequences for businesses, no doubt about it, and likely for the average person who's buying something in the store. But for our trading partners, I basically say just keep on going with your conversations, because I don't think the president's going to change his mind anytime soon.
Terrific. Thanks, Kathleen. I think that's a great place to end. Thanks to each of you for spending the time. It's a great conversation. And I'll just sign off by saying this is Michael Smart. We appreciate you joining us for this session, and we look forward to seeing you next week on WEDA's Friday Exchange.
Thank you for watching and listening to WEDA's Friday Exchange, a media product of the Washington International Trade Association. If you haven't already, be sure to subscribe on Apple Podcasts, Spotify, or YouTube. New episodes drop every Friday, and you'll be the first to know. Thank you for joining us, and we'll be back next week with WEDA's Friday Exchange.